And Jason Van Dyke's explanation of what we all see in that video may be really, really critical for jurors, because he's saying, bottom line, look, this is simple. The video is taken from this direction. I was looking at things from this direction. The two don't match up. You can't see the critical movement of the knife in that video. And that movement is what Officer Van Dyke believes is going to be enough to get him off the hook, at least on the most serious charges, if not on all of the charges. Attorney Rahul Manchanda is here with me on the Law&Crime Network to help break this down. You do criminal defense, immigration, civil rights law. What do you make of this video? Does this guy's version of this, that the video doesn't show everything and that there was this threatening knife movement that you can't see from lower right to upper left, is that enough for him to be justified in pulling the trigger?
I really don't see it. I really don't see how he's going to get out of this. I mean, 15 shots, 16 shots, and apparently now apparently he was standing when it happened. You know, I was scratching my head during the break. I was like, why aren't they claiming an insanity defense here? Because this is absolutely something that I you know, as a defense attorney, I would just be absolutely balking right now. You know, it's something that how do you explain that? I mean, you know, it's one thing to say, okay, you know, post-traumatic stress, you know, what do you do under fire? Police officers have to make quick, you know, crack decisions under pressure. You know, we all know this, but in this situation, I just don't understand what happened here. And I'm really, really wondering why an insanity defense wasn't interposed or something along those lines. It just doesn't seem to me that you could really, you know, how do you do that, you know, in this situation? I really
well,
can't
look,
see
I mean, this is going to boil down to a justification defense in Illinois, and it's interesting because if the jurors go to second-degree murder here, it sort of splits the justification defense. Right. The jurors can turn around and say, yes, we believe that this officer thought he was justified, but looking at it objectively from back here, he was not justified, and they can split it that way and then go to second-degree murder.
Right, but they also hit him with 16 additional charges, I think, right, in this situation. So, of assault charges, I believe, right? And so, you know, I'm really scratching my head and wondering as to where they're going with this, where the defense is going with this, because to me it just seems super excessive. It's not even a little bit excessive, it's super excessive. And I'm just kind of wondering, what is their strategy at this point? You know?
Well, look, their strategy may just simply be to knock that top murder charge out and then let the chips fall where they may. If he's convicted of all these different elements of the lesser charges, then he may be able to serve them at the same time and be out in 5 or 10 years. It could be something like that. But look, we're going to continue to break this case down here. We're talking about the Jason Van Dyke case in Chicago, where jurors are back in that deliberation room as we speak. We will be back with more after this. And we're continuing to listen to testimony in the Jason Van Dyke case. That was the pathologist talking about the wounds that the victim suffered. Of course, I'm here with Rahul Manchanda. We're talking about the Jason Van Dyke case. What do you make of this cancellation of a local football game? Offices going into lockdown just in case whatever this verdict is, assuming it's going to come back today, causes trouble there in Chicago?
Well, look, you know, midterm elections, political issues, there's a lot of money exchanging hands. It's a very big political issue right now. You know, we've seen this in our country over and over again. I mean, you know, even back in the 60s. So there is potential for riots here. I mean, I don't think that anyone's going to be happy with this verdict, whatever it is. There's not going to be one outcome that is going to be conceivably less or you know, less traumatic or troublesome in society. People really forget about that. These kinds of trials are followed and don't necessarily divide the country, but definitely, you know, give voice to certain people who may use it for their own nefarious or good purposes, whatever the case may be. But this is an election season. This is about race at the end of the day. This is a police matter. This is, you know, a racial matter, and you can't really escape it. So I think that there has been probably some intel that's passed down about maybe some talk or some murmurs here and there. And I think the law enforcement, federal, state, local, are doing what they have to do to maintain order, because they don't want to be caught with their proverbial pants down, God forbid, and if there's any damage, and they want to be prepared. They certainly don't want to be accused of being lax with security, God forbid if something happens, but riots have happened for less. And so, you know, this is an election season.
Look, I know when the shooting happened, it called for all these, it led to calls for political resignations. It led to protests. Some of that was the way the local authorities handled this when it initially happened. When the video eventually came out, it told a different story from the official line, and then that just angered people all the more. But at this point, it seems to me that somebody has to stand up, and this is just my own opinion, but somebody's got to stand up and say, this is what the law says. This is how the jury reaches decision. If the decision of the jury is totally out of whack, that's one thing. Right. But at some point, people got to look at those jury instructions and look at the statute and say, they are colorblind. They resulted from an analysis of fact and a conclusion of law that was made after wrestling with the facts. It's a question of justification, ultimately, and if people believe this was justifiable, he walks. If they believe that it was not, then he's in trouble. And that's what it boils down to.
Absolutely. But, we're lawyers and we see the world that way. Facts, law, statutes. We're trained to do this. The average American, some of these people out there have, personal problems, anger management issues. There's also forces at work which are taking advantage of things like that to polarize certain people for voting purposes. It's a very contentious election coming up, big hot political football. So, we can say that all we want, but the reality is what's going to happen on the ground is really what's going to happen on the ground. I don't really think anybody knows what's going to happen at this point. When this verdict comes out.
Yeah, we're going to wait and see here, folks. Again, this jury is deliberating, and if the jury does not reach a verdict this evening, it will be a sequestered jury. The question, how late will they go? What will the outcome be? Will this be first-degree murder? Will it be second-degree murder? Will it be none of the above? Will it be an acquittal on the top charge? Those are the choices that jury is wrestling with as we speak. We will be continuing to break down the Jason Van Dyke case when we return. There you had both sides of that dichotomy. One version saying that these injuries would have caused almost immediate death. The other saying, no, we were at the scene and the victim had signs of life. Rahul Manchanda, we're talking about this. Your analysis.
Like I was saying earlier, that, whenever you have an expert versus somebody who's live on the scene, there's such a huge difference, and it really, in terms of experience, my experience has been somebody on the scene live kind of knows a little bit more about what's going on than somebody who's an expert reading documents, making a determination, analysis. Sometimes even worst case scenario on the defense side, experts are even less likely to be believed because they're paid.
Police officers are paid to testify for the prosecution.
Well, defense experts, that are privately paid experts, even judges, take it with a huge grain of salt. But when you have somebody on the scene, alive, an officer, a paramedic, that carries a huge amount of weight. And I would take that into more consideration than an expert, some intelligent person sitting behind the scenes with documents. They're not there. They're looking at paperwork.
It's the old high school exam question. What's more reliable, a first-hand source or a second-hand source? A second-hand source wasn't there to actually watch it go down.
Absolutely.
And here, again, is it of the essence just how long the victim died, or is this more of a case about justification?
Well, again, that's a great question. It goes to showing, veracity. That's really what this is about, is veracity. It doesn't really go to the meat of what you're talking about. Obviously, this goes to, who's telling the truth, who can be believed, who's more compelling. And whenever you can blow something up or in somebody's face and show that there's, a veracity problem, a truth problem, you can use it to your advantage. You're kind of moving the momentum to your side. So I think that's what it's about, not necessarily about what you're talking about.
And it very well could be. Look, we're continuing to break down the situation in the Jason Van Dyke trial this afternoon as jurors deliberate the fate of that former Chicago police officer, seated right there on your screen. Jason Van Dyke said he believed he was justified when he pulled the trigger because Laquan McDonald was moving a knife from his right hand, which was near his waist, up across his chest and towards his left shoulder. The officer thought that was enough of a threat to pull the trigger from 10 to 15 feet away. But prosecutors say this was unreasonable. It was unreasonable for that officer to pull the trigger. And of course, this squad car recording that we have watched so many times here at the Law and Crime Network is, in the mind of the defendant, just not worth very much because it only shows the incident from behind and not from the perspective that he saw when he pulled the trigger. You see the victim move his hand from his right side, but the rest of it is blocked. We don't see the entire range of arm movement. We're going to be back with more about the Laquan McDonald murder case when we return after a quick break here on Law and Crime. So here we heard from the defense use of force expert talking about the distance between the defendant and the victim, Laquan McDonald, when these shots rang out. Rahul Manchanda is here with me on the Law and Crime Network to continue to break this thing down. 13 feet is sort of what they're estimating the distance between these two to be. Is it enough for that victim to have really posed a serious threat to the officer.
You know, I was going into this thinking that the defense was going to make me even less inclined to believe it. But to actually, when you put it into perspective, 13 to 14 feet, you know, and in the heat of the moment, and then they said it would take 1 point something seconds to reach him. You know, in that situation, and again, we were talking earlier about the police department training to, you know, these officers to multiple shots. I mean, 1 or 2 shots, I could explain that. You know, you're scared, you're in a moment, you've got to defend yourself. 1 or 2 shots, but 15 to 16 is super egregious. But then, you know, as you said earlier, I guess that is police training. Multiple shots, unloading their weapons. When you make that decision, that crack decision, you've got to do it. I think if it was 1 or 2 shots, I think it'd be more easily justified. But 13 feet is really not a lot of feet, if you think about it. You know, so in that moment, the heat of the moment, you don't know what he's going to do. So I think that defense expert was very, very good for the defense.
Yeah, look, jurors are breaking this down as we speak in that courtroom in Chicago. Some of the pictures from the area in the neighborhood showing dozens upon dozens upon dozens of officers lining up on bicycles on the streets to provide security in case things go haywire when this verdict comes down. We're continuing to follow it. We will be right back here on the Law&Crime Network. There we had a psychologist getting ripped up a bit by prosecutors on cross-examination there. Look, Rahul Manchanda, if the psychologist is going to analyze the defendant, should he be doing so over Skype?
Again, this whole...
not ideal, but, you know, look, he at least admitted not ideal.
Look, it's common today to do this via Skype. I mean, even hearings are done telephonically, so that's not a huge problem. But I think this series that we just witnessed was absolutely brutal for the prosecution. Absolutely brutal for the prosecution. I came away thinking, you know, look, you know, don't do the crime if you can't do the time. If you're going to be playing these kinds of games with big men with guns who are there to keep law and order, you might get shot. You might die. You might get hurt. You know, and I think that, you know, it's wonderful that we as a society are looking at these things more and more, you know, cutting them, you know, slicing them like onions. But I mean, at the end of the day, you know, a couple generations ago, we wouldn't be having this conversation. If you were drunk or on PCP or on drugs, you know, creating mayhem and havoc in the street with police around, and they all have guns, you could die. And that's just the way it happens. You know, crack shot, you know, war is hell, bad things happen. You know, we can't get so sensitive to the point where we're, you know, and I'm watching these defense witnesses, and they're absolutely astounding. These are people saying, look, you don't know what's going on in his mind. It's a crack decision, 13, 14 feet away. The cop said, the officer said he was, you know, the back was to the wall. We meant the squad car. You know, in that situation, what would we do? What would the average person do? You know, you've got to neutralize the threat. And they could have, you know, he could have been on him in a couple seconds.
Well, you know, this is where I have to start slicing and dicing this.
Absolutely.
Because, look, the way that police officers are trained,
right,
seems to me to not be what the law says. They're trained, you know, neutralize, eliminate the threat, shoot, center, mass. I don't see that in the justification statute. I see reasonableness analyses. So why aren't they trained that before you pull the trigger, you better be able to defend yourself as to whether what you're doing is reasonable? Of course, if they're trained that way, then I'm sure that critics who would jump all over me would say, well, then more officers are going to get injured or killed.
Well, absolutely. The reasonable standard is a reasonable standard, but it's a reasonable police officer, not a reasonable lawyer standard, a reasonable milkman standard, a reasonable...
The police get to set the standard of when they pull the trigger and inject it into the law, or does the legislature get to tell the police, you do it this way, because that's what society dictates?
It reminds me of saying that, you know, judge not the man who's not in the arena, you know, that kind of thing, the one who's actually there. You know, it's very easy to judge somebody in there. That's why lawyers police themselves in disciplinary committees. Medical profession polices themselves. You know, there are certain fundamental things that occur that are, you know, specific to the profession itself. It's very easy for a layperson to sit there and say, you know what, that's horrible. I wouldn't have done it that way. But unless you're in there, you have guns in your face, you could die any minute, you might not come home to your wife and kids. You really can't make a judgment like that. And that defense was absolutely brutal to the prosecution. I got to say that. I didn't feel that way before I saw it. I got to be honest. You know, you know, they were composed. He had, you know, composure, very well reasoned. You know, the 13 to 14 feet was a huge part of it. I think the time frame within which he could have been overtaken was a huge factor. You know, the Skype is nonsense. I mean, that's just. Look, I mean, we live in
a state trying to find a way to show.
Right, we live in 2018. You know, look, I mean, you know, for example, you know, judges are being bussed in all the time. They're doing hearings by telephone. Lawyers. This is the world that we live in. It doesn't make it less, you know, effective.
We are continuing to break down, ladies and gentlemen, the Jason Van Dyke case out of Illinois, where jurors have been on the clock throughout the afternoon trying to determine whether that former Chicago police officer is guilty of first-degree murder, second-degree murder, or should be acquitted on the top charge. Of course, those jurors are also examining a number of other lesser charges, including official misconduct. We're waiting to see if they come back with a verdict sometime this afternoon or into the evening, or whether that jury will be sequestered from this point forward in deliberations. More on the Jason Van Dyke case when we return from this quick break. Into some very graphic testimony there from that member of the Cook County Sheriff's Office. Again, this is a different office. We're in the same county, but the defendant's a member of Chicago PD. This is Cook County Sheriff's Office, and there, Rahul, we're talking about basically this victim bleeding out on the street.
Yep.
The medical examiner and the medical testimony was that he died basically from the blood loss, from the number of bullet wounds that he suffered. And here we've got this officer, he gets up on the stand and he's saying, oh yeah, that's the victim's blood just draining out of his body and running down the street towards the curb.
Absolutely prejudicial, though, as a statement, isn't it? I mean, the image is extremely gory. That's what you want to avoid, though, right? You want to kind of avoid painting that picture, that gory, graphic image of blood draining into the gutters. I mean, this is, very prejudicial, but it doesn't have to do with the law, doesn't have to do with the facts, doesn't have to do with, the statutes. Again, it's something that is extremely, prejudicial.
This is one of the last witnesses in this case, so one of the other things this witness wanted to talk about is exactly whose job it is to start doing CPR and attending to the victim after a shooting like this, and there's apparently some competing policies out there. One policy with the Chicago Police Department, another policy with the Sheriff's Office, and questions as to exactly what we want police officers trained to do. Are they police officers or are they paramedics? Let's continue with that member of the Cook County Sheriff's Department's testimony. Testimony there from a member of the Cook County Sheriff's Department about exactly whose job it is to start resuscitation efforts after a police shooting. Rahul Manchanda. Do we want our police officers doing the job of paramedics because they're there when shots are fired, or do we want to leave that to the paramedics? And even so, look, I know I'm asking a split question here, a compound question. You can't object. Why is it relevant to this case?
Well, look, you're exactly correct. We don't want police officers doing the job of a paramedic because at the end of the day, they might be defending themselves. And like we have here, the paramedic is giving completely different testimony than the expert witness. So if, it's a total conflict of interest here. That's all inadmissible. Any defense attorney could get that thrown out. So yes, we don't want that. We want there to be a delineation and a firewall, if you will, between the police department and the paramedics. There really has to be separation, almost like separation of powers, because it's just a complete conflict. At the end of the day, do we really think that the police officers and the paramedics have the same interests at heart? Probably not.
And the other part of the question here, too, why these different policies between Cook County Sheriff and Chicago Police about whether or not they're supposed to jump in there and do CPR?
Well, between different counties, look.
Well, it's not different county. I mean, it's Cook County, and then Chicago is part of Cook County, but it's a separate police agency.
Different jurisdictions, different locales have different rules, and we're allowed to do that. That's what happens. But unfortunately, you're absolutely correct. There are going to be disagreements, and there are going to be conflicts. But in this situation, this is symptomatic of the criminal justice system anyway. That's part of the problem. I mean, it's almost like the federal immigration system, for example, is tying it all together. They're wrestling with it at the Supreme Court right now. What is the definition of an aggravated felony or crime of moral turpitude? No one knows what the heck it is. What is one prohibited act in Texas is completely allowable in New York and vice versa. So this is the conflict that we're having. It's a federal system. We're a relatively new country. We're not like Europe. We have the Justinian Code, the Civil Code for thousands of years. We're still a common law-based country. We're still, building our case law. And I think that this is something that you see in a criminal trial on a regular basis. So you will see that kind of a conflict going on.
We're continuing to break it down here. We're talking about the Jason Van Dyke case out of Chicago, where jurors have been in the deliberation room through most of the afternoon. Will they come out with a verdict today, or will deliberations push into another day? Bottom line, jurors are sequestered after this point if they don't come up with a verdict today. We're monitoring the situation. We will be back with more here on Law and Crime in just a moment. So here we have a series of witnesses who had interactions with victim Laquan McDonald in some juvenile detention facility, getting up there and saying, look, Laquan McDonald was a troublemaker. He didn't listen to us. He didn't cooperate with us. He caused all of these issues. So, Rahul Manchanda, let's break this down. I'm assuming Illinois follows something similar to the way the federal rules of evidence work. And generally speaking, and I've got the rule open in front of me here, as I oftentimes do, a defendant can offer evidence of an alleged victim's pertinent character trait. Okay? So that comes in. But then if it happens, the prosecutor can rebut it. So the prosecutor could have gotten somebody up here to say, Laquan McDonald's a nice guy, he's a peaceful guy, he was turning his life around. I don't recall hearing that. And it could have been rebutted by saying that the defendant, the officer, has all these issues as well. So the fact that this comes in, and the fact that the defendant took the stand and that opened him up to a whole range of cross-examination, this suggests to me that this defendant's got to have a pretty squeaky clean record, because he got on the stand, which opened him up to having his record basically really thrown in his face if there was anything negative in it. And he's got this testimony in about the victim's character, which then would have opened up a whole range of other testimony against Jason Van Dyke. But there Jason Van Dyke sits, and all of this negative stuff never came in against him. That suggests to me that he's pretty clean.
Yeah, and that's a great deduction. What if it's not the truth, though? I mean, that's what's astounding to me in the situation.
Surely the prosecution's got to know if he's got issues on.
Well, we've
like
got three witnesses here testifying to the character of this victim. But what about I'm just curious. I mean, does the officer have any disciplinary problems? Has this been approached yet? Has he done it before? They did talk about comments and statements that were made on the way to the scene, correct? Which it's a crapshoot. Is that really a character thing, or is that an incident thing, contemporaneous with the incident? That's a question. But it's still, in my opinion, to be conservative, that's a character statement, in my opinion. And if they've opened up the door on that level, where's his personnel records? Where's his history? Does he have any complaints in his past? Has he ever had any excessive force complaints? Has he ever made any racial comments? Has he ever made any incitement comments? Things of that nature. That was a very cowboy comment, they said, right? That he said, okay, we've got to go down there and
have to shoot this guy.
Correct.
Something like that.
Okay, which is damning. Okay, but the question is, was that a character statement? Or was that, an incident statement?
Well, they got it in because it's one of the elements that they need to try to prove this first-degree murder
right,
charge.
But nobody knows what's in this guy's history. I don't know.
Look, if this guy had never made that comment, this would not be charged as first-degree murder.
Absolutely.
I'm certain.
Absolutely correct. And that's
they needed
why,
to get that intent element in there.
Right, and that's why we really need to know, does he have a propensity for this kind of thing? Has he ever been in trouble for this stuff? Is there anything in his personnel file? From what I can see, from what I can hear, nothing has been talked about this. And I think that's incredibly important. Why? Because if this is a heat-of-the-moment thing, if this is something that happened in the heat of the moment, that he felt threatened, it was 13 to 14 feet, the guy was hooked up on PCP, the whole 9 yards, imminent, clear and present danger, he had to make a crack decision, that's one thing. But if the guy has a propensity for this kind of stuff, and he was just a hair trigger kind of personality, a cowboy, if you will, he's made comments on the job, kind of thing, that's something really that the people really need to know about. And I'm astounded, based on the fact they've just paraded 3 character witnesses to trash the victim's memory. Why aren't they doing this with the live defendant? That's really my question.
He might have, by logical deduction, a pretty clean character.
But we really shouldn't be deducting anything. This is a trial. It's not about deductions.
I'm
and
just
guessing.
saying from an analysis standpoint.
Yeah, that's why somebody's asleep on the job here. Somebody's not doing their job, in my opinion. I mean, this is incredible. This is a huge question that I have going forward. We're almost at the end of this case. So.
Well, we're at the end. Look, jurors have been deliberating here for a little bit more than 3 hours. They're going to be sequestered at this point if they do not reach a verdict this evening. How late will they go? We're waiting to see. We'll be back after this here on Law and Crime. Jason Van Dyke himself on the witness stand. Look, folks, jurors appear to be deliberating into the evening in this case. But bottom line, legally, this is going to come down, in my opinion, to that all-important question of justification. And there are two parts to justification that jurors are going to have to wrangle with. One is the sort of justification for a shooting that society would recognize as legal. Society might look at this and say, yes, we believe that an officer facing a threat, as depicted in the video and as described in the evidence, is the sort of threat that society believes an officer should be able to pull the trigger for. And was this particular defendant justified inside his own head? Jurors are going to have to get into his head. They're going to have to look at what society would recognize. Rahul Manchanda, what do you make of it? Justified or not on those standards?
Absolutely, and that's exactly the question. But what we were talking about earlier is I'm kind of wondering about his personal history a little bit as well. That's really important. The whole purpose of a trial is to elucidate and bring out the truth. Somebody should have brought this up, and again, we had mentioned earlier that maybe because they're not talking about it, maybe there's nothing in there. Maybe there's nothing derogatory. Maybe he hasn't acted up before. Maybe he has never made a statement or made a comment or acted in a way that tended to show an imbalanced personality or prone to violence. And if that's the case, if he doesn't really have any personnel problems or any records in that respect, then maybe maybe it was justified. Maybe this was an anomaly. Maybe this is one of those things wherein you had to be there and he had to make a decision. Because if he doesn't have a propensity for violence, a propensity for discrimination, a propensity for being a cowboy, quote unquote, or making stupid decisions, then who are we to judge?
Maybe he's thinking clearly. Look, we have to wrap things up. Appreciate you joining us today here on Law and Crime. Keep watching on our dedicated feeds, on lawandcrime.com. We're going to sign off for now with live programming here on the network to continue tomorrow morning. Have a good evening.